and stuff.
You got it.
Ain't nobody saying that right now.
Yeah, we're waiting on the judge.
Oh, okay. That 22 over. He got the TC at 20, at 22 over.
Let's work on that.
Good afternoon, Judge.
Good afternoon, everyone.
Good afternoon, Your Honor.
Happy Saturday. Hello, Mr. Jordan.
Good afternoon, Judge. How you doing today?
I'm good. Happy sunny Saturday. All right, we're ready to go. Let's see. I see Miss Gardner. Are you by yourself, Miss Gardner? You don't have any help?
Oh, no, Mr. Berger's here as well.
There he goes. Okay,
Nice to
good.
see you,
Now-
Judge.
Nice to see you.
I'm here as well, Your Honor. We wouldn't abandon Miss Gardner.
Wouldn't have been good. How are you, Miss Falk? Good. I see Miss Hogue. Okay, there we go. Now, Anita, Helen, good. Okay. All right, ladies and gentlemen, good afternoon. My name is Judge Regina Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have been recently arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused these cases of the offenses brought against them, and these cases have been bound over to the State Court of Fulton County. Nevertheless, this will usually be the defendant's initial appearance before a state court judge. So we are going to address several matters, including bond, possible arraignment, and consideration of a possible plea offer. One has been made by the state at this juncture. Going to also be providing you with a reset date for arraignment if it is not held today. And what is our reset date?
It's June the 28th, Judge.
June 28th?
I'm sorry, June the 9th.
Oh, okay. I was gonna say it's a long time away. Okay, gotcha. June the 9th. All right. June 9th. And let me begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. And I want everyone to also know on the calendar that you do have a constitutional right to representation as well as the right to remain silent. Remember that anything that you say about the facts, circumstances, and the occurrences regarding your case can and will be held against you. So defer to your attorney, follow the instructions so that you don't hurt your case for later. All right, where are we starting, deputies?
Good afternoon,
morning.
Judge. We're gonna be starting in courtroom 2 with position 9, Mr. Haynes.
And after position number 2, we have position number 7 at the South Annex, Your Honor.
South Annex, you know, the jail's supposed to go first and you all supposed to go after we get done.
Okay. All right. And you said it's position 9 in courtroom 2?
Yes, thank you, Judge.
All right, thank you. All right, is this Mr. Michael Haynes Trent? All right, this is case number 22 CR 003367Y. You're charged with 1 count of obtaining a lawful entry into MARTA and criminal trespass. The offense date is May 27, 2022. Pre-trial, do you have anything?
Yes, Your Honor. Good afternoon.
Good afternoon.
GCIC indicates 42 cycles with history in Georgia, Maryland, and North Carolina. Last arrest, November of 2019 for parole violation in LaGrange, Georgia. Underlying charge was not indicated. Record does indicate the defendant is currently on probation in Fulton County for theft by take-in. 13 SC 121477. Sentenced September of 2019 with 10 years probation. Record also indicates 1 failure to appear, 1 violation of probation within the past 10 years, 2015, 2 misdemeanor convictions for theft by shoplifting out of LaGrange, a 2019 theft by shoplifting out of Troup County, 2019 theft by taken misdemeanor, 2015 theft by mislaid property, and a 2015 theft by shoplifting. Nothing further to add.
All right. All right, and Ms. Gardner or Mr. Borg?
This is gonna be my case. I just want to be clear, is this Mr. Haynes, position number 9?
Yes.
Okay, I had 25 cycles. But nonetheless, that's actually irrelevant. The bond on this case was already set at a $2,000 surety. It's $1,000 each. I have no argument, no objection to keeping the bond at the same. Again, I'm seeing 25 cycles, but just would like to see our citizens pay for MARTA. So I am going to ask that the bond remain the same.
He
Okay.
has 25
Let's-
cycles in Georgia, but he has 11
Ah.
cycles in Maryland and 6 in North Carolina.
Got it. Thank you.
22.
Thank you, pretrial. I appreciate the clarification. All right. Ms. Ho? You're on mute.
Am I off now? Yeah, okay.
Yes, there we go. All right.
Thank you.
Uh-huh.
Mr. Haynes Trent is 36 years old, Your Honor. He's been in Georgia for a little over 8 years. He currently works at a place called Polo Contract where they break down and they clear out, of things after events and, fairs and whatnot. And before that, he's done a variety of jobs from door-to-door salesman, telemarketer. He's done everything to remain as consistently employed as he can, Your Honor. He also does have a GED, as well as he actually ended up graduating from high school. He is single with, no children and things, but he has significant number of aunts and cousins who also live in Georgia. So he does have significant family ties. In accordance with his history, my understanding, Your Honor, is that parole violation from 2019, that he is not on probation or parole any longer. He actually has completed that. So that is over. And all I see in his history is things back from 2019 and 2015. I do not see any violence or anything in his history. He has limited finances, Your Honor, so a $2,000 surety bond is definitely not within his reach. We would ask that to be given his ties, the fact that he has a job and everything else. We'd like to see that changed to a $2,000 signature bond through pretrial or the jail, as that is something I think that's more attainable for him at this time.
All right. Was he already on a warning or criminal trespass warning from MARTA?
I believe so, though I think he thought it was up by now.
Yes, he was. I have the date.
Okay.
Yeah.
So
I believe it went from something like the 24th or 5th to June 5th or something like that.
That sounds familiar. I want to say the expiration was supposed to be in June.
Yeah. So he was not aware that it had not expired at this time, Your Honor.
Okay.
days away.
All right. Is that someone, I think TCL, whoever that is, you need to mute yourself. I'm getting feedback. There you go. Thank you. All right, I'm going to modify his bond to 1,500. And that will be 500 on the unlawful entry and 1,000 on the criminal trespass for a total 1,500 surety bond. I'm going to also order that he stay away from all MARTA while on bond. You'll have to find some other means of transportation or ride share, Mr. Haynes Trent, while you're on bond. And no drugs, alcohol, or weapons while on bond. All right, so that's $1,500 surety bond. That should conclude this case. Anything else?
No, Your Honor.
All right, thank you.
Position 8, Ms. Jeter.
No, it's actually pronounced Peter. Doesn't really matter, but.
Hold on 1 second. All right, Ms. Jeter, this is case number 22 CR 003366A. You're charged with 1 count of criminal trespass and a 2nd count of simple battery family violence, both with the offense date of May 28th, 2022. pretrial?
Your Honor, no prior history. She is recommended for UJR through pretrial. Nothing further.
All right. Right, Mr. Borger?
Thank you, Your Honor. The state's asking for a $5,000 surety bond total. That's $3,000 for the simple battery, $2,000 for the criminal trespass. Your Honor, in this case, the defendant got into a fight with her mother, Miss Jean Kellebrew. This defendant had kicked down Miss Kellebrew's door and subsequently pushed her to the ground. I understand some other property within Miss Kellebrew's house was damaged. Miss Kellebrew was taking in her daughter for the stay to help her daughter get back on her feet when this incident had occurred. Along with the bond amount, we are asking for a no further contact with Miss Jean Kellebrew. That's last name is spelled Kille, B as in Bravo, REW. A stay away from 3265 Mangum Lane, MANGUM Lane. Enrollment in the anger awareness program, and no guns, drugs, and alcohol while on bond. I do understand that Miss Kellebrew is present on this Zoom call, so I would like to recognize her if she would like to speak. Nothing further from the state.
All right, Ms. Kellebrew. Can you hear me? Ms. Kellebrew?
Unmute, better.
Okay.
Hello?
Yes, can you turn on your camera for me?
Oh, I thought it was on. I apologize.
Okay. All right, would you like to address the court today?
Yes, I have a couple of clarifications.
Okay, raise
To
your right hand
ASA.
for me. Hold on, raise your right hand for me.
All right.
Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, I do.
All right, you put your hand down. What would you like to tell me about this incident?
The incident, my daughter is, I believe that there are some emotional issues in play, along with some general depression. She is of late prone to violent outbursts and crying and this sort of thing. She has refused what help is available for her in an emotional or psychological capacity.
Okay, does she live with you?
Pardon me?
Does she live with you?
Yes, she has lived with me since October of 2019, just prior to COVID, when she relocated from New York after a 12-year stay.
Okay. All right. Are you in fear of your daughter, Ms. Jeter?
When she loses it and becomes verbally and or physically abusive, in generally that is taken out on things, but nevertheless I feel that if that continues to escalate and she does not get any help, it will indeed manifest itself in more than just shoving me and my falling.
Mm-hmm. And so does she have somewhere else to stay?
There is some family here. She has friends. I'm really not certain or privy to, she's 42 years old. And she is very much an adult and keeps me at arm's length with her personal dealings. I cannot say in good faith that I do not want any contact. I would like an additional few days of cooling off before she comes back here, like through the holiday. I mean, I realize she is my daughter. I love her. I just cannot continue to feed into whatever this thing is, knowing that I'm going to get hurt in it. Now the other thing, the address is incorrect. It's 3165 Mangum Lane. And other than that, that's about all I have to add to it.
All right, Ms. Holt, do you have any questions?
Your Honor,
Yeah.
one, just briefly, I think that in light of what Ms. Killebrew has said, I think the state would also like, at least for the defendant, to either undergo a mental health evaluation and treatment or meet with the social worker, have some scheduled follow-up meetings, just to make sure that any concerns are sufficiently addressed in an appropriate way. Thank you.
Okay. All right, Ms. Holt, do you have any questions of the witness first?
No, Your Honor.
Okay, then you may present.
Thank you, Your Honor. Ms. Jeter is in fact 42 years old, Your Honor. She is a high school graduate from Grady, as well as she has an MS Master's in Fine Art for photography. She did live in New York for a while and did move back with her mother. I'm not going to get into what the family dynamics are. I've done this long enough to tell you that there's two sides to every story and that Ms. Jeter is presumed innocent until proven guilty. Whatever their issues are between them is what's between them and their perspectives. As you can see, she has absolutely no criminal history, either here or in New York. So that speaks to the fact that she has no violence in her history or anything else. She was currently working as a bartender, but I believe she has injured her knee. So right now she is not able to work until she gets her knee fixed. As far as where she can live, it will be up to the court to decide whether or not that they would allow her to move back home with her mother or not. And again, I will reserve that for the court versus trying to address that and what I understand the relationship to be and the problems potentially in the relationship. As far as anything like mental health goes, there's no indication she has any mental health issues other than what her mother is stating is her mental health issues, which she is not a professional herself. She has been approved for a pretrial release, and I believe she is entitled to a pretrial release. Currently, because of her knee injury, she is not working, so anything financial would be a strain on her. If the court decides that she can't return to her home, then she can go live with a cousin or friends. That is also fine, Your Honor. But I do believe she's entitled to the pretrial bond release that she has been approved for, given she has no history, no violent history, no anything. And as I said, this is a family matter and everyone has their own perspective.
All right. The state has recommended an MH eval. At the very least, are you able to have her evaluated by the social worker for your office?
I don't think so anytime soon, Your Honor. You'd be holding her in here for an MH evaluation that is not dictated by any criminal history, only by a statement from her mother, whom she was in an argument with, Your Honor. So I think holding her up here and not giving her a signature release that she's entitled to, if you don't want her to return to her mother's house, that's fine. If you wish when she's out to do an MH review, but this is the holiday weekend, Your Honor. So it would not be anytime soon. You'd be holding her in jail just based on a non-professional statement with no former history looking to that. So I do believe she's entitled to the signature release. If you feel that she needs to get one when she's out, that is certainly fine. You can certainly put that as a requirement that has been put as a requirement by other people. But to hold her in for that, no, I do not believe that is appropriate.
Okay. Anything else, Mr. Porter?
Nothing from the state, Your Honor.
All right. I'm going to order the $5,000 signature bond. That will be $2,000 on the criminal trespass, $3,000 on the simple battery, family violence. And I'm going to order that through pretrial. I'm going to order a stay away from 3165. We correct that address, 3165 Mangum Lane. And so, Ms. Jeter, you need to go find other housing for yourself because you cannot return to your mom's home. You're to stay away from there. If you do, you will be arrested. No further contact with your mom, Jean Keller Brew, at this time. I'm going to order no drugs, alcohol, or weapons while on bond. And I'm going to order you to take the one-day anger awareness course. And I'm going to ask that you, on your own, when you're released, seek some mental health evaluation or some type of evaluation to see if there's some issues that you may need to address. But once you're released, you can do that on your own. All right, is there anything else from either council?
No, Your Honor, and I'll speak to Ms. Jeter later on if she
Okay.
has any questions.
Okay, good, thank you.
The total bond was 5,000 through pretrial.
Yes, 5,000 signature bond through pretrial, yes.
Next, we have position 18, Ms. Wesley.
This case number 22 CR 003378D. Ms. Jasmine Wesley, you're charged at one count of simple battery. The offense date is May 28th, 2022. Do you have anything pretrial?
14 cycles with history in Georgia, DC, and Maryland. Last arrest, June of 2020 for criminal damage to property, second degree, cruel to the children, third degree, and cruel to the children, first degree in Clayton County. No disposition listed on that arrest. Record does indicate the defendant has open probation in Clayton County for criminal trespass, 19 CR 10622, sentenced September of 2021, 48 hours confinement and 12 months probation. One failure to appear within the past 10 years, and a 2013 malicious destruction misdemeanor conviction in Maryland. Nothing further to add.
All right, Ms. Gardner.
Your Honor, in this case, Miss Wesley pulled Mr. Raphael Mathis to the ground by his hair, leaving a red mark on his head. Even though there were visible injuries, the state has accused it as simple battery. And as we have heard, Miss Wesley is a multi-state offender with a substantial number of arrests, and we know of at least one failure to appear. We're asking for a $3,000 good bond, anger awareness program, no contact with Raphael Mathis, stay away from 2113 DeForest Ferry Road, and no alcohol, drugs, or weapons.
All right. Ms. Helen.
Good afternoon, Judge. Miss Wesley is 31 years old. She's currently a bartender. She does have college experience at Montgomery Community College. She's a lifetime resident of Fulton County here in Georgia. She is the proud mother of one son currently who's 2 years old. He's currently right now with her father in Clayton County. Judge, we're going to ask for a signature bond for Miss Wesley today because effectively any other bond would be a no bond for her. She is not able to bond herself out on any of her resources. Again, after being incarcerated, Judge. So we are asking for a signature bond. If not that signature bond, we are asking for a $1,000 surety bond. I did hear the one FTA, Judge, but I spoke to Miss Wesley. She understands the seriousness of this charge and will appear to all of her court dates. I do not believe she will be reoffending while out on bond. She does not want any contact with Mr. Mathis. She would like a one-time escort to retrieve any of her items from that location, and she will not be in any other contact at all with Mr. Mathis. So yes, Judge, we are asking for that signature bond today.
All right. I'm going to order a surety bond in the amount of $3,000. I'm going to order no further contact with Raphael the victim, and I'm sorry, I forgot the last name,
Mathis.
Mathis. No further contact with him. Stay away from the 2113 DeForest Ferry Road. And no drugs, alcohol, or weapons while on bond. And I think that will conclude this case. 3,000 surety.
Understood.
Okay, thank you.
Position 12, Ms. Malone.
This is case number 22 CR 00-33708. Is it Aaliyah Malone or Aliyah?
Aaliyah.
Aaliyah. All right. You're charged with one count of simple battery family violence with the offense date of May 27th, 2022. Pre-trial?
No prior history. She does meet the criteria for UJR through pretrial. Nothing further.
All right. Ms. Gardner?
Thank you, Your Honor. In this case, the defendant was arguing with her mother about infant formula for her daughter. And during the argument, she punched her mother in the back of the head with a closed fist. They do live in the same household. We're asking for a $2,000 good bond, no further violent contact with her mother, Annie Malone, FVIP, no alcohol, drugs, or weapons.
Okay.
And Your Honor, Miss Aaliyah is 19 years old, and she currently has her GED. She's a lifetime resident of Fulton County. She does have a 10-month-old daughter that, yes, she does live with her mother with. That's why we are asking, number one, for a signature bond. And number two, Judge, we would ask that there be the stay away be removed, because effectively, if she's not able to return there with her daughter, she will be homeless. And I do believe I have spoken to her mother. Mother may be amenable to her returning. So I would ask if that stay away can be removed. If it can be a no violent contact. And again, Judge, as you heard, she does qualify for a UJR through pretrial services. So we are asking for that signature bond. And if not that signature bond, a $1,000 surety bond, Your Honor.
Okay, do you know, you said she would be.
Hey, I just wanted to say something real quick.
Oh, is that Miss Malone?
It's Aaliyah, yes.
I'd advise you not to speak on any of the information here because it'll be held against you, okay? But if you have a question just about procedure, ask me, okay?
Okay.
Yes, Judge.
I was trying to ask, you said that she doesn't have anywhere else to go, that she would end up being homeless.
And Judge, there's one other location, but the main primary location is with her mother that she resides at. So that's her primary location. She does have another address that she may be able to reside to, but the 4900 Delano Road is her primary address with her daughter.
Does she work?
No, Your Honor. But again, she does have her GED. She is looking for work, but her primary residence is with her mother, but she is not currently working now.
Okay, has the state had an opportunity to talk to the mother at all?
Our advocate has attempted to reach her. There was no voicemail available, so she was not able to leave a voicemail and was not able to get her. Being that the allegations are that she punched her mother in her mother's home, the state would ask that at this time she not be allowed to return there, and that possibly the bond could be modified later if the mother feels comfortable having her return at a later date.
Which she will, because.
Well, hold on, Miss Malone. Hold on.
Okay.
Ms. Malone, you do have counsel, so you need to defer to your counsel and not speak out.
All right.
Okay. I will give the UJR, the signature bond through pretrial in the amount of $3,000. And I'm going to order the one-day anger awareness course. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to go ahead and enter the stay away from 4900 Delano Road. And irrespective of the stay away, I'm going to order no further violent contact with her mother because I understand she has a 10-month-old. So there's possible, daycare or her mother assisting her with the baby. You cannot stay at that location, Miss Malone, but you can have contact with your mom as long as it's not violent. I'm concerned about that, of the allegations. I'm sorry?
I said it's not gonna be violent. All these right here.
Oh, Ms. Malone, please, again, don't talk about the current case, okay?
Okay.
So we're going to do this as a cooling off period. And if your mother, once you're out, and if you don't have any other place to stay or any other resources, she can contact the solicitor's office or contact your attorney, Ms. Helen, and then they can possibly bring it back for a bond modification if your mother wants you to reside in the home with her. All right, and I see our victim advocate. Is there anything else you need to add on this case, Ms. Taylor? Okay, just making sure. All right, is there anything else I need to take up?
No, Your Honor.
All right, thank you. That will conclude this case.
Position 17, Ms. Warner.
This is 22 CR 00337A. Ashley Warner, you're charged with 1 count of simple battery family violence with the offense date of May 28th, 2022. Pretrial.
15 cycles. Last arrest, September of 2018 for simple assault in Fulton County. That was a conviction, 18 CR 007413G. Record indicates a 2012 DUI and driving while license suspended in Douglasville, Georgia. 1 failure to appear, 2 violations of probation within the past 10 years. She does meet the criteria for UJR through pretrial. Nothing further.
All right.
Thank you.
Gardner, yes.
Thank you, Your Honor. In this case, Ms. Warner struck Mr. Chester Batiste in the face. They do reside at the same location, although they do have no children together. Mr. Batiste informs our advocate that this is not the first time that Ms. Warner has laid hands on him and that he does not wish for her to return. I also believe that he is present with us if the court would like to hear from him as well. And looking at her entire history, I am seeing 6 failures to appear in her history, as well as one probation violation. She also has a violent conviction of assault. The state is asking for $3,000 good bond. Stay away from 6465 Kimberly Mill Road in Atlanta. Have no contact with the victim, Chester Batiste. Anger awareness course, no alcohol, drugs, or weapons.
Okay.
Yes, Your Honor. Ms. Warren is 33 years old. When I spoke to her, she has not been recently working due to a disability from a car accident, Judge. So she's not been working recently. She does have her GED. She is a lifetime resident of Fulton County. However, she is also a proud mother of 4 children, 2 twin 9-year-old girls, 1 7-year-old son, and then 11-year-old, her oldest, which is her oldest daughter. So Judge, I am asking for a signature bond for Ms. Warner. I have heard her history. However, I didn't hear a repeating case with Mr. Bastille, who she does not necessarily want contact with. She understands the seriousness of this case, Judge. She would be asking for a one-time escort for any of her belongings from 6465 Kimberly Mill Road. But Judge, I do believe that she was residing there with her children, Judge. So I would ask for that stay away to be removed. if it can't be determined whether or not she can live there with her children. Again, that's where her children do reside. So I would be asking for that stay away to be removed. Again, Judge, I am asking for a signature bond. If not that signature bond, I'm asking for a surety bond of no more than $1,500. And again, I did hear, I believe from pretrial, that she does qualify for that UJR through pretrial services.
Okay. Can we ask on the record, Ms. Warner, if that is it a home or an apartment, and who's on the lease, if it's rented or the deed?
It's actually, Mr. Betsy's house.
Okay, it's his home.
Mhm.
All right, I'm going to order a $2,000 signature bond through pretrial. I'm going to order the one-day anger awareness course. I'm going to order no drugs, alcohol, or weapons while on bond. And I'm going to order the stay away from 6465 Kimberly Mill Road. And I'm going to allow one-time escort back to that property to retrieve any personal belongings of Ms. Warner and or her children. And I'm going to order no further contact with Chester Batiste. All right, $2,000 SOB pretrial.
Understood, Judge.
Mhm. All right, that will conclude this case.
Next, we have position number 7, Ms. Farmer.
Okay. This is case number 22 CR 003365G. Not the sure Jesula or Jesula Farmer. You're charged with 1 count of battery family violence, offense date May 25th, 2022. Pretrial.
Record indicates a 2007 battery in Broward County, Georgia. No disposition listed. She does meet the criteria for UJR. Nothing further.
All right. And Mr. Borger.
Thank you, Your Honor. The state's asking for a $5,000 surety bond. Your Honor, in this case, defendant's daughter, who is an 13-year-old girl, young lady, had called the police and then informed the police that her mother had struck her with an electrical cord. Ms. Farmer was upset when she found out that Aaliyah was having some troubles at school. And so she used an electrical cord to discipline Miss Aaliyah. Officers arrived and were given permission to look at Miss Aaliyah's back, and there was some welts consistent with ones that you would see when hit with an electrical cord. DFACS was called, and I understand that Aaliyah is in DFACS custody. So with that in consideration, along with the $5,000 surety bond, the state is asking for enrollment in a parenting class, a continued no further contact for as of right now, and no guns, drugs, and alcohol while on bond. Nothing further from the state.
All right. Ms. Hogue.
Yes, Your Honor. Ms. Farmer actually has lived in Georgia for quite some time now, Your Honor. She's been in Georgia for 7 years. She has 4 children, 35, 26, 22, and 13. This child, all 3, the other ones are older, have moved out and are quite successful, Your Honor. She herself has an accounting degree in which she's working at her master's on. She works for Heritage Property, where she's been there for 3 years, so she has significant ties here. And she's working, as I said, on her master's degree degree from Southern New Hampshire. And having reviewed this and knowing what I know about defects in investigations, Your Honor, I do believe that that'll be up to them to exactly what happened here. My understanding is that Miss Farmer turned herself in. when she found out that her child had been taken, she went down to find out what was going on. They told her she had a warrant to come back and go to Fulton County on Friday, to Fulton County Courthouse. She went there. They didn't know what was going on. So then she went back to Sandy Springs. She continued to follow up with them and turned herself in there, showing that she is not a flight risk. She has absolutely no history other than this alleged battery from, I've got to say, about 15 years ago, for which there is no disposition. She has been approved for a signature release, so I do believe she is warranting a signature release given her lack of history. As far as any other conditions go regarding her daughter and contact and everything else, Your Honor, and parenting classes, I do believe at this point it's in DFACS's hands. DFACS generally comes in, does an evaluation, determines what they need, determines any contact, determines all of that. So at this point, I would not want to interfere with anything that DFACS would be doing. I believe just simply a signature bond at this time, and then to conform or follow with anything that DFACS requires of her is more than sufficient at this time, Your Honor.
All right. I'm going to order a $5,000 signature bond through pretrial. I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order the one-day anger awareness course. And I'm going to also order, which DFACS may do as well, that she take a parenting class. I'm going to also order no further contact with the victim, her daughter, unless it is mandated or authorized by DFACS. They may authorize some reunification or visitation, depending on what their decision is. But if it's not ordered by DFACS and she's to have no contact with her daughter while on bond. And I think that is it. Is there anything else that I need to take up with either counsel?
Nothing from defense, Your Honor.
All right. Anything from the state?
Nothing from the state, Your Honor.
All right, that will conclude this matter.
Thanks so much, Your Honor.
Next, we have position 16, Mr. Smith.
Wait, hold on a second. All right. Let's say that position again, I'm sorry.
Position 16, Smith.
Okay. It's 22 CR 003374D, Theodore Smith, charged with 1 count of DUI, less safe, and a 2nd count of making an improper U-turn, both with the offense date of May 28th, 2022. Pre-trial.
Second arrest. First arrest was April of 2011 for DUI. That was in Richmond County, Georgia. No disposition listed on that arrest. He does meet the criteria for UJR for pretrial. Nothing further, Judge.
Okay. All right, Ms. Gardner.
Thank you, Your Honor. In this case, the defendant was pulled over after the law enforcement officer observed him making an illegal U-turn where there was a sign posted saying no U-turn, as well as a red left turn arrow. After stopping him, the officer observed that he had watery eyes, his speech was slurred, there was a strong odor of alcohol coming from him. After he stepped out of the vehicle, he had difficulty holding himself upright and straight. When questioned, the defendant seemed to be confused about where he was. He was stopped in Roswell, but when he asked if he knew where he was, he said he thought he was in Cumming. He also was not aware of which exits he might be between on the interstate. He was on Holcomb Bridge Road, which is exit 7, and he said he was traveling from exit 14 to exit 16. He did refuse to take any field sobriety test or the state test. We do have the prior arrest of the DUI. We also show a no-low plea to reckless driving in 2011. The state is asking for a $6,000 good bond in this case with no alcohol or drugs while on bond.
All right.
Yes, Your Honor. Mr. Smith is 33 years old. He's currently unemployed. However, he does have his bachelor's degree from Augusta University in communications. He has been in the Georgia area for the last 15 years. So he does have strong community ties. He does not have any children, Judge. However, when I spoke to him, he does understand how serious these charges are. I've spoken to him. He does plan to attend all of his court dates. I do believe I heard that he does qualify for UGR through pretrial services. And Judge, if you feel that he doesn't qualify for that UJR, I'm asking for a surety bond of no more than $1,500. That's $1,000 for the DUI and $500 for the illegal U-turn.
All right, he's 33 years old.
Yes, Your Honor.
Okay. And I see he's raising his hand. You can instruct him to.
Yes, Mr. Smith, if you have a procedural question, you can ask me, but if you want to make any statements about the case, I advise you not to do that. Any questions for me?
I'm not unemployed, ma'am. I apologize for making a statement, but I'm not unemployed.
You go ahead, tell us where you're working right now, Mr. Smith.
Yes, ma'am. I have never been unemployed. I work in sales for a tech company here in Atlanta, ADP.
I apologize, Your Honor. That was my mistake. Mr. Smith has been employed for several years, but Judge, we are still asking for that signature bond.
All right. But I'm going to order a $3,000 signature bond through pretrial with $2,000 on the DUI, $1,000 on the U-turn, for a total of $3,000. No drugs, alcohol, or weapons while on bond. I'm going to order that there be no driving except if you have a valid license, and to work to see your attorney and to seek medical care. So limited driving under these circumstances while you're on bond.
Did you understand that, Mr. Smith?
Yes, ma'am. One question on that. So does that mean my license is not suspended? I am allowed to drive forward?
I'm not sure. I am not sure. You'll need to check on that when you get out on bond, since you do have a signature bond. So you do need to find that out before you start driving to work to see your attorney or for medical care.
Yes, Mr. Smith, her stating that you can drive is under the impression that you have a valid license. So this is all instructions with a valid license, okay? So you need to double check to see if that's your situation with the DMV.
Yes, ma'am. Thank you.
All right.
And Judge, is that the free trial?
Yes, that is through pretrial. I'm sorry. I don't know if I said that or not. All right, if nothing else, that will conclude this case.
Thank you, Judge.
Position 1, Mr. Brown.
This is 22 CR 003379J. Mr. Roderick Brown, you're charged with 1 count of obtaining a lawful entry into MARTA and criminal trespass with the offense date of May 27th, 2022. Pretrial.
41 cycles. Last arrest, May of 2021 for theft by shoplifting. Record does indicate the defendant is currently on probation for robbery, case number 09SC75867. Sentenced February of 2009, 10 years confinement and 10 years probation. 3 violations of probation within the past 10 years. A 2017 felony conviction for terroristic threats and a battery conviction. Nothing further to add.
All right. Mr. Porter.
Thank you, Your Honor. The bond is currently set at a $1,500 surety. That's $1,000 for the criminal trespass and $500 for the unlawful entry. The state has no objection and does ask that the bond be kept as it's currently set. Again, with 42 cycles, we would like to see the defendant at least pay a surety rather than a signature bond. Nothing further from the state.
All right, Ms. Holt.
Yes, Your Honor. Mr. Brown is 47 years old and is currently homeless without any type of support. So I understand that while that is not a prime or wonderful way to ask for a signature bond, but Your Honor, he has no way of making any kind of bond, which means essentially whatever the bond would be unmakeable. So given the fact that this is it is an unlawful entry and a criminal trespass based on a trespass violation, Your Honor, and given his financial circumstances, and this is not a violent crime, we would ask, Your Honor, that he be given a signature release at this time, because like I said, otherwise he has no way of making any kind of bond at this point.
And so where is his family?
I'm sorry, Your Honor, he has no family. He is homeless here.
And he's not from Georgia?
He is from Georgia, Your Honor. He has been here all of his life, but at least in speaking with him, he has no family or children that he's been able to communicate to me with.
All right, I'm going to order a surety bond in the amount of $1,500, $500 on the unlawful entry into MARTA, and $1,000 on the criminal trespass. I don't know if he already was under a stay away from MARTA, but I'm going to order that he stay away from all MARTA. If you return to any MARTA locations, Mr. Brown, you will be immediately arrested. So you'll need to find other means of transportation. I'm going to order no drugs, alcohol, or weapons while on bond. And that should conclude this case, I believe.
What type of bond is it, Judge?
Surety bond, $1,500.
Next, we have position 13, Patel.
This is case number 22 CR 003371E. Mr. Hiren Patel, you're charged with 1 count of criminal trespass. Offense date May 27, 2022. Retrial?
14 cycles. Last arrest February 2022 for criminal trespass in Fulton County.
This one.
No disposition listed on that arrest. Record indicates a 2019 criminal trespass conviction, 2017, 2 separate criminal trespass in 2015, and a 2015 reckless conduct. Nothing further, Judge.
All right. Ms. Gardner?
Thank you, Your Honor. In this case, the defendant was found sleeping in a stairwell of Georgia Institute of Technology property without consent after having received a criminal trespass warning on December 5th, 2020 for a 2-year period. The state feels it is very probable that this defendant will reoffend. He has, we show 6 prior criminal trespass convictions and an arson arrest by the Georgia World Congress Center that was reduced to reckless conduct. We're asking for a $2,000 good bond in this case, that he be ordered to stay away from all Georgia Tech property and no alcohol, drugs, or weapons while he's on bond.
Okay.
Yes, Your Honor. Mr. Patel is 29 years old, and as you've heard through court, he is residentially challenged. So in seeking shelter, he's run into these arresting offenses, as you have heard, Judge, in 2022, 19, and 17. When I spoke to him, I stated that our office does have social workers who may be able to come down and speak to them about residential housing, Judge. But today we are asking for a signature bond for Mr. Patel. We do understand that there may be a stay away from all Georgia State locations, but Judge, I did want to make the statement that he is 29 years old. He is not a violent offender in any recent cases, and that he be given a signature bond for this particular case, Judge. And if not, the signature bond, Judge, a $500 surety. Again, he's homeless. He would not be able to make anything more than that $500 surety.
All right. Did I hear you giving me any information on his work history?
Judge, he is not employed. He has been in the Georgia area for the last 3 to 4 years, Judge, but he's not employed.
Okay, education.
Judge, he does have his GED.
All right, I'm going to order the $2,000 signature bond through pretrial.
Your Honor, I apologize. If he's homeless, he's not a good candidate for pretrial.
Because you don't have an address.
Correct.
I'm gonna do a signature bond through the jail.
Understood, Judge.
All right, $2,000 signature bond through the jail. Mr. Patel, when you get out, keep in contact with your attorney to make sure that the court has an address for you in order to get future court date notices. So I'm going to hope that you will do that. Keep in contact with your attorney. I'm going to order no drugs, alcohol, or weapons while on bond. And I'm going to order you to stay away from all Georgia Tech properties, the campus, and any of the surrounding properties that are owned by Georgia Tech.
I apologize, Judge. Was it Georgia State or Georgia Tech? I thought it was GSU.
Oh, did I make a mistake? Which?
I believe it's Georgia Tech, Georgia Institute of Technology.
Okay.
Okay, Georgia.
Understood.
Tech. Okay, thanks for that. Make sure we're doing the right thing. All right, so stay away from all Georgia Tech properties while you're on bond, okay? All right, that should conclude this case.
Thank you, Judge.
Position 6, Davis.
This is 22 CR 003362C, John Davis. You're charged with 1 count of battery family violence, a 2nd count of cruelty to children in the 3rd, and a 3rd count of simple battery family violence, all with the offense date of October the 3rd, 2021. Pre-trial?
Now, if you can have a moment, I have to grab the file from felony.
Oh,
first
okay.
offense. One moment.
Okay.
I can begin.
Yes, go ahead,
I
Mr.
have-
Porter.
Okay, thank you, Your Honor. The state's asking for a total of a $10,000 surety. That would be $5,000 for the battery family violence, 2 for the cruelty to children, and then 3 for the simple battery family violence. Again, total $10,000 surety. Your Honor, in this case, the defendant was upset because his daughter, or a daughter that his mother's the mother of his child also has, 11-year-old girl, was talking back to this defendant, and the defendant was upset. So the defendant called this little girl's mother. His mother is someone that he also shares a child with, and said that he wanted to discipline her. Of course, mother, Ms. Quavel Reese, returned home immediately to try to interfere. And that is when the defendant had hit Ms. Quavel Reese in her face multiple times in front of her 11-year-old child, Destiny. The violence didn't stop. Mr. Davis then hit Destiny, the 11-year-old girl, in front of her mother, Ms. Quavel Reese. This incident is from October of 2021, but looking at the GCIC, the delay is because, first off, the defendant had left the scene when police were called, but was also in with Clayton County for a criminal trespass, simple assault with an incident date of March 2022. And we just received a disposition for that on May 26th of 2022. In November of 2021, the defendant was charged with aggravated assault. The defendant in this case slammed his other daughter's head into the ground and then shot a bystander in the back. I got 13 cycles, a robbery in 2008, guilty conviction, a battery family violence arrest in 2018. This concerned a different victim. It was eventually no prost, along with a terroristic threats with a different victim, but in this case, the defendant was found guilty. Along with the conditions with the $10,000 surety, we're asking for no further contact with Ms. Quavel Reese. The two, Ms. Quavel Reese and Mr. John Davis, share a child together. Stay away from 2909 Campbellton Road. Enrollment in a family violence intervention program, no guns, drugs, and alcohol. With regards to the simple battery family violence, same conditions except no further contact with Ms. Destiny Reese, that is Ms. Quavel Reese's 11-year-old child, who Mr. Davis hit in front of her mother. Nothing further from the state.
All right. Ms. Hogue?
Yes, Your Honor. Mr. Davis is 35 years old, Your Honor. I'm not going to get into his criminal history. Obviously, it exists. First off, I'm a little confused here because I read what I got of the arrest report, and there's nothing indicating he ever touched Destiny Reese. According to this, supposedly he was going to, and the mother stepped in the way and he hit her instead. So at this point, I'm not sure where that's coming from. Obviously, it's not any information that I was given, but there's nothing indicating that Ms. Destiny Reese was ever hit in the information that I was given. So I would like to clarify that, number one. This did happen over almost 8 months ago, Your Honor. As far as leaving the scene, right now, we don't know exactly what happened. He was not there to speak to anything. We don't know when he came, when he left, or anything else. None of that was actually stated to any degree. As far as the no contact, my understanding is that Ms. Quavel Reese, the only child they share, is 18 years old, doesn't live with Ms. Reese. And in fact, Ms. Reese no longer lives in Metro Atlanta. In fact, I'm not sure she's even in the state of Georgia any longer. So the no contact is not a problem in this case whatsoever. I would like to say that Mr. Davis has been here for quite some time. He's been here all of his life. He has a GED. He is currently attending Lincoln Tech, getting his electrical systems technician. He's been there 2 months and has a year to go forward to get his certification and everything. He has a father, sisters, kids here, so he has significant family ties, so he is not a flight risk, Your Honor. He's been working at Peachtree Golf Course landscaping for 8 years, as well as set in service, temp service for 10 years, doing stock and shelves rebuilding. So he has significant ties here. So I do believe a reasonable bond in this case, given the fact of the age, the fact that he was not even aware of these warrants. He'd had contact with Ms. Reese several times since then, who said nothing about any warrants being issued to him. This is very much what I hear oftentimes. So it puts a question to exactly what did happen. Your Honor. So at this point, we'd ask for just reasonable bonds of $1,000 each on each charge, especially given that we never even saw anywhere where he even touched Destiny Reese. So I'm not sure where even that's coming from.
All right, I'm going to order a $5,000 surety bond. And that breakdown will be $3,000 for the battery family violence and $1,000 for the cruelty and $1,000 for the simple battery. That totals $5,000 surety bond. No further contact. Is the victim is Destiny Reese?
The victim, I believe, her name is not Destiny Reese. That is the child. I believe the victim is who I can't. I'll say it. Quavell Reese.
Quavell. Okay, Quavell Reese. But there's that cruelty charge on there as well. I guess relates to Destiny. So are they both victims, Quavell and Destiny?
Yes, Your Honor. The cruelty is that the alleged hitting of her in front of Destiny.
Okay, so I'll make sure that there's no further contact with either of them. No drugs, alcohol, or weapons while on bond. And as far as the incident location, are we clear as far as whose residence that is?
Yes, Your Honor. He doesn't live there. I'm not even sure Miss Reese lives there any longer, so a stay away is not an issue for either.
Okay, great. All right, and that should conclude this case.
Thank you, Your Honor.
Thank you.
Position 19, West.
All right, this is 22 CR 003375Y, Terry West. You're charged with 1 count of criminal trespass. The offense date is January the 27th, 2022. Pre-trial.
Second arrest, first arrest was April of 2021 for possession of marijuana with intent to distribute. That is an open case, 21 CP 1986. I'm sorry, 21 CP 198969. He was granted a UJR through pretrial. Pretrial is surrendering that bond. Nothing further.
All right, Ms. Gardner.
Thank you, Your Honor. In this case, the defendant was temporarily employed at Party Bake, a business. He brought a handgun into the building in his backpack, then went into the break room and he removed the handgun from the backpack and he put it in the waistband of his pants. Now, seeing this, Miss Manager Tanya Zeissner, Zeissner, told him to leave, but he refused to leave. He stayed on the property for another 2 hours with that handgun. And the reports are that he behaved aggressively towards the other employees and he told them before he left that he would be back. Now this arrest was in January, but the state has quite a few concerns. He was being fired. He was asked to leave and he refused to leave for 2 hours. He had a gun and he behaved aggressively towards the other employees. We have serious concerns, especially in this environment, about people coming to situations of conflict with a gun, especially when they have grudges against the people that they may be having contact with. He also, as was stated, has an open felony drug case for which he was already on bond through pretrial services. So the state in this case, even though it is a criminal trespass case, we are asking and seeking a $4,000 good bond, that he take the anger awareness course. Our advocates have spoken with Miss Zeisner, I hope I'm pronouncing that correctly, and she has asked that he be ordered to stay away from their business of Party Bake at 6160 Boat Rock Road in Atlanta, and that he have no contact with any employees there. So the state is seeking a stay away from that location and a no contact with any employees of Party Bake. No alcohol, no drugs, and absolutely no weapons while he's on bond.
All right, Ms. Helen.
Yes, Your Honor. Mr. West is 29 years old. As you heard, this incident happened at a location he was previously working. He was unaware that this entire incident had happened until I then read him the arrest affidavit. These are still allegations, Judge. So when he was asked to leave, he did leave. And then he was asked the management there if he could stay not on the property, but stay and wait for the bus. There's a bus location there, Judge. So let's talk about allegedly a gun was pulled out. He was asked, but I didn't hear any allegations of a gun pointed at anyone. Anyone physically saw a gun on Mr. West or his person in person at all, Judge. Because if it was, we'd be dealing with something that's not a criminal trespass. So today I'm asking for a signature bond for Mr. West. If this happened in January, Judge, this is a very serious allegations. We're asking for a signature bond for Mr. West. He is definitely fighting this case. And if not that signature bond, we are asking for a $500 surety bond, Judge. Again, he was working at that location. He does have his GED. He is a lifetime Georgia resident of Fulton County, and he does not currently have any children, but he does have strong family ties. He was working there. He does have family in Georgia, Judge. So again, there were no allegations of a gun pulled out towards anyone. So want to make sure that we understand this is a criminal trespass. And he believed he did leave and was waiting for a bus until being arrested later, and then having to hear the allegations from me, myself, Judge.
Okay. And is he working at the present or unemployed?
Unemployed, Judge, due to being arrested from this incident. He was working again full-time, temporarily, but full-time with the Waffle House warehouse.
Oh, okay. All right, I'm going to order a $2,000 surety bond. I'm going to order that there be no drugs, alcohol, or weapons while on bond. I'm going to order that he stay away from the incident location, Party Bake at 6160 Boat Rock Road. And I guess there's nothing else to take up unless council wants.
No, Your Honor.
Okay.
Your Honor, the manager did specifically ask for the court to consider no contact with any of their employees.
Okay. And I'll order no further contact with any employees of the Party Bake business located on Boat Rock Road.
Mr. West, if you have a procedural question, you can ask me, but I advise you not to talk about any of the events of the case that we're currently talking about, okay?
I know you advised me that, but I still have to ask you, this is just vital, because first off, this is absolutely asinine, because I've been locked up in January. But anyway, I heard pre-trials state the fact, the first thing that they stated, they were revoking my other bond, so I'm gonna be here, correct? I just need some understanding, because I'm really severe of what just happened, the falseness, lies, all of it. I'm really paying attention, so I just want some understanding.
You're gonna go back to court in 2 weeks.
Okay, thank you.
All right, thank you.
That's it, you're done. Next, we got position 10, Jones.
Good morning, Your Honor. Good afternoon.
Yes.
All right, Mr. Sherman Jones, this is case number 22 CR 003368A. You're charged with 1 count of battery family violence. The offense date is May 27, 2022. Retrial.
There are 11 cycles with history in Georgia, Arkansas, and New York. Last arrest was April of this year for possession of Schedule 1 controlled substance in Cobb County. That appears to be an open case. Record also indicates an open case for willful obstruction of law enforcement officers by use of threats or violence, 22 CP 206036 in Fulton County. He was granted a UJR through pretrial. Pretrial is surrendering that bond. He has a 2018 misdemeanor conviction out of Arkansas for domestic battery, third degree. Nothing further to add.
All right, Mr. Borger.
Thank you, Honor. The state is asking for an $8,000 surety bond. Your Honor, in this case, the victim, Ms. Shronda Blossom Game, called the police and informed them that she was struck multiple times in the face. The defendant had allegedly had a cell phone in his hand and had hit Ms. Blossom Game multiple times. There was a visible laceration to Ms. Blossom Game's face, and she did go to the hospital where this is waiting for a potential felony if stitches were required. The defendant went on to blame Ms. Blossom Game for her own injuries, said that she was having a mental health breakdown and this was her fault. Not to mention, Ms. Blossom Game is 7 months pregnant with their own child. The defendant has cycles out of here and Arkansas, including a domestic violence conviction. I see also aggravated assault guilty conviction from 2008. So this is a violent defendant who is awaiting a potential felony transfer. Along with the $8,000 surety bond, the state is asking for, of course, no further contact with Ms. Shronda Blossom Game. That's SHRONDA, last name Blossom Game, BLOSSOM GAME. Stay away from 302 Mansell Road in Alpharetta. That's the Ramada Inn. That's the incident where this or the location.
That was my room. That was my room.
Okay. Mr. Jones, don't speak. Mr. Jones, don't speak.
I'm sorry, ma'am, but
Mr. Jones, don't speak. Mr. Jones, don't speak.
Enrollment in a family violence intervention program, and no guns, drugs, and alcohol while on bond. Nothing further from the state.
All right, Ms. Holt.
Yes, Your Honor. Mr. Jones is 31 and notably upset for many inaccuracies in this right now. But he's 31 years old, Your Honor. He moved here to Atlanta about 7 months to a year ago. He's now currently employed at a car spa in Holcomb Bridge as a detailer. He was working as a cook at Five Guys as well, Your Honor. He moved here to be with his daughter and the mother of his child at that point, as well as he has older brothers, aunts, and cousins. So he has significant ties here in Georgia, which is why he moved here for that and for work. Right now, Your Honor, just to clarify, because I've actually spoken to Miss Blossom Game. Okay. First off, Your Honor, neither Miss Blossom Game nor Mr. Jones called the police. Okay, they're currently staying at a hotel. That's where they've been staying while they're looking for an apartment. So that is why they're at hotels right now. So it was an apartment. It was someone at the hotel who supposedly heard them arguing, and that's who called the police. So Ms. Blossom Game did not call the police. She did not say she'd been repeatedly hit, and I spoke to her right before this whole hearing started. She wants contact. She's at work right now, Your Honor, so she couldn't be on this call, though she said if I wanted her on this call, she would get on this call. She did say they were tussling, and she did go to the hospital, and they sent her right home with a little bit of a Band-Aid, no stitches or anything of that nature. She is not 7 months pregnant, Your Honor. It's something I also asked her about. She is 7 weeks pregnant, not 7 months. So I also would like to clarify that as well, Your Honor. She actually currently is working for an attorney and also in planning to go to school or continue to go to school when she can to get her own degree. So at this point, Your Honor, given the actual facts as we know them at this point, we are in fact asking for if not a signature bond, Your Honor, something along the lines of a $2,000 good bond. I don't think anything in here qualifies even close to what they're asking for, Your Honor. This is not going to be a felony. Is she did not call. She does want contact, and her words were they were tussling, and that was it. So there was not repeated hits. I'm not sure where some of this is coming from.
Your Honor, this is coming from a police report. And the fact that a patron at the Ramada Inn called the police as opposed to Miss Blossom Game, it makes this situation worse because now Miss Blossom Game is in a situation where she's being hit and doesn't feel that she can safely call the police. And it's also loud enough for other patrons in the hotel to hear. Miss Blossom did go to the hospital. Coming back with the bandage does not automatically make it not a felony. When people get stitches, they come back with a bandage on their nose. Again, we think that a surety bond alone is appropriate, but at that amount of $8,000, again, 7 months pregnant with the child.
Your Honor, she's not 7 months pregnant. I talked to the woman. Did you all talk to her? I spoke with her right before this. And I can also ask her to go over to a room to get on.
Pregnant. She is not 7 months, sir. I'm sorry, Your Honor.
Okay, yeah.
Miss
Sir,
Elizabeth,
let me speak with you.
No.
Mr. Jones, let me speak.
Please.
I am speaking for you. She is 7 weeks pregnant. She told me that. She told me it was a tussle and there was no fear in her voice whatsoever.
I just want to go home and get my service.
Mr. Jones, please.
I want to get my dog out of
Mr. Jones, please. Mr. Jones. Your Honor, like I said, I spoke with her. I'm not sure who else and where all this is coming from because I also read the report. And there's nothing like that in the report other than the inaccuracies of 7 months pregnant, which is not correct.
It's in the warrant.
It's in the warrant, but it's not correct.
Well, the fact of the matter is we got to go off the police report because the victims it's known that victims minimized in this situation. Ms. Hogue, we would love for you to share the contact information with our victim advocate so that we can get to the bottom of this. But we have sworn testimony from an officer that this victim is 7 months pregnant.
Nevertheless, she's pregnant, period.
She is pregnant. That is correct.
Right. So we do know that. We could agree that she is pregnant. Whether it's 7 weeks or 7 months, still she is currently obviously knows that she is pregnant or has confirmed a pregnancy.
She has confirmed a pregnancy, Your Honor. And like I said, if you want, she wants contact. And if you want, I can try and get her on. She just was at work. So, it was very tough for her to get on. But if I want, I can contact her if you'd like to speak with her.
Is it possible to put her number in the chat to Miss Taylor, the victim advocate, so she could call her? I would like to know a little bit more, especially with a pregnant person. I mean, that may precipitate some more charges by the state. I don't know, but I would like to know that if Miss Taylor could call her. We don't want her to lose her job if she's, pregnant and potentially going out on maternity leave, but if she could answer her phone and talk to Miss Taylor, I would love to hear that.
Okay, I will go ahead and put her number in there. And if you don't mind, then I'll also let her know to be expecting that call. Okay. So,
yes.
Sometimes people don't always answer if they don't recognize.
When they see a weird number, correct.
Yeah, so I'll go ahead
and Miss Taylor, are you calling from a 613 or 612 number or some other number?
Good afternoon, Your Honor.
Good afternoon. I'm sorry. And I know you may have a county cell. I'm not sure. Okay, so it won't be a 612 or 613, correct?
No, it'll be a 404.
It'll be a 404. Okay.
404 what?
I don't want her to say that.
Yeah, I'm not
on-
gonna say it out.
Okay. Well, if
She
you'll
can,
put
she
it
can
in,
chat it. She can chat it back to
you
you.
can chat it back and we'll go back and forth on the chat, okay, Your Honor? So that
Yeah.
we can then, if you want to move on to another one, I'll be glad to handle
Right,
that.
we'll hold on that.
Hold
Deb.
off on your case. Go have a seat over there for me, Jones.
Okay, thank you.
Mr. Beal, position 2.
Okay. This is Marlon, is it Bowie?
Yes, ma'am.
Okay. 22 CR 003359F, near charge of 1 count of theft by receiving stolen property. The offense date is March 2nd, 2022. Pre-trial?
13 cycles
I'm
with
sorry,
history
13.
in Georgia and Illinois.
I'm sorry,
Last-
pre-trial. How many did you say? I didn't hear you. 13?
1-1.
Oh, 1-1, okay.
I'm sorry, 13.
1-3, thank you.
11 cycles out of Illinois.
Okay.
March of this year for theft by receiving stolen property. That is an open case in Shabley, Georgia. That case number is D as in David 0288881. I have 3 convictions of Illinois, 2017 aggravated assault with says use of weapon/vehicle, 2015 possession of controlled substance, and a 2010 aggravated battery. Those are felony convictions out of the state of Illinois. Nothing further to add.
All right. Mr. Porter?
Thank you, Honor. The bond is currently set at a $5,000 surety. The state does ask that it remain at a $5,000 surety. In this case, Your Honor, the defendant was seen in March of 2022 stealing the victim's car tire. This is from out of Georgia Tech. Security footage shows the defendant arriving at this Georgia Tech parking lot wearing the ski mask. He manually lifts up the gate, drives through this parking garage and finds a tire to steal. Coincidentally, this defendant was arrested in May of yesterday on a separate traffic offense. But the description of his car matched the bolo that Georgia Tech had placed when they observed the security footage from March 2nd of 2022. And it looks like the defendant hasn't gotten rid of the tire. The tire was still in the vehicle that matched the description of the vehicle that the defendant would be in when he is alleged to have stolen the tire out of Georgia Tech. So we are asking for a $5,000 surety bond to stay away from Georgia Tech. No further contact with Mr. Dominique Young. I don't have any reason to believe the defendant knows Mr. Young, but just a no further contact be in place in case they do. And enrollment in a theft prevention class, along with no guns, drugs, and alcohol while on bond. Nothing further from the state.
All right. Ms. Ho?
Yes, Your Honor, I need to clarify a couple of things. First off, he's already been arrested for this. That theft by receiving in March in Chambly is this case.
In Chambly?
Yes, it's
Chambly?
right here in the report, Your Honor.
Is there
Okay,
part
and
of Chambly that's Fulton? I thought Chambly was DeKalb and something else.
yeah, that's right. On Friday, this whole thing, this alleged, first off, he's never been identified. Step one. And the car was not the car he drives right now. He drives a Mercedes. You'll see that in the traffic stop that he was stopped at, Your Honor, he drives a Mercedes, not a Kia Stinger. Okay, according to the report and the vet that we have been given, on 3/2/2022 at 5:30, a black Kia Stinger bearing a Florida temporary tag entered the facility. They were wearing someone was driving, another person was in a ski mask. Okay, that's not his car. That car's never been attached to him. Now, supposedly it came in and left 10 minutes later. No one saw anything of what happened. They're just assuming that that's what happened. In fact, Mr. Young couldn't tell you when anything happened because the last time he saw it, he had the car parked up there on the 28th of February and then came and saw it and looked at, on the 3rd of March and noticed his tire was missing over a 5-day period, Your Honor. So there's no exact timing onto exactly when this tire was taken. However, there was a bowl put out on this black Kia Stinger. On 3/4/2022 at 3 o'clock, the Chamblee PD located this alleged vehicle, the black Stinger, not associated with my client, arrested 2 occupants, in fact, more than 2 occupants. It was in a barber shop where they were arrested, Mr. Buell and Mr. Wilson, and got a search warrant and searched that car at that time for this case. So at this point in time, he's already been arrested. Chamblee got a search warrant, and that has already been handled. Okay, he got stopped today. Somehow or another, even though Chamblee did that, Fulton went and took out a warrant like whatever, 8 days later or something, and that's what they're going on, is this warrant taken out later. Okay, but even in the report here, this was handled and arrested in Chamblee. Now, I imagine because it was arrested in Chamblee, however, the incident happened in Fulton, was probably the delay in the warrant. Okay, but he was already arrested for this. Okay, this has already been handled in that regard. So you are arresting him yet a second time for something he was already arrested for a search warrant was done, and it just took 8 days for the Fulton police to put a warrant out on something that he'd already been arrested for. So at this point, until they can, I would ask for a signature bond on this part. And it is not the Mercedes he was driving. It was not even identified as his car.
Yeah, sorry to cut you off, Ms. Holt. Mr. Borger and Ms. Falk, is there any way to, and I know I always have Ms. Falk do my research for me in the background to see, that does concern me a little bit. If this was a Chamblee case and then Fulton took out a warrant as well, just want to make sure if we can find that out. I don't know.
I can look into it, Your Honor. It's a Saturday and a holiday,
Right.
so the likelihood of me getting anyone on the phone is
Answer you
probably
in Chamblee to tell you, or in Atlanta, either way.
right. However, I would make a little point about this. Case law is well established that the thief cannot also be the recipient of stolen goods. So the theft by receiving actually would not be the appropriate charge. It would be the theft by taking here in Fulton that would be the appropriate charge. So in any case, and we're not conceding that he has been doubly charged, but in the case where he may have been, which we've had cases like that in my 18-year career frequently, what we do, the appropriate thing to do is to dismiss the Chamblee case and proceed on the Fulton case, because the Chamblee case legally cannot proceed based on that issue of the recipient also not being the thief.
And Your Honor, I do believe it's an issue of whether or not they could make a theft by taking, because no one was identified. They don't even know for a fact that this happened at that point. Okay, Your Honor, there was a 5-day period upon which this person, Mr. Young, did not have contact with the car. No one saw anyone take a wheel off his car. They just saw this car come in and out in a 10-minute period.
And Your Honor, that's an excellent argument for Ms. Hogue to make at trial, as she well knows.
Yeah. But that's why, Your Honor, at this point, like I said, my feeling is he's been arrested on this, Your Honor. So I believe a signature bond on this particular charge is warranted at this time.
All right. Anything further, Mr. Borger?
Nothing from me, Your Honor.
Okay.
Now, he does have the second traffic case, Your Honor.
That's not before us today, but
Actually, it is. It's number 3.
Oh, he is the second case today. I'm sorry.
Yeah, that's what I said. The number 2
Okay,
case.
I see.
Yeah.
Okay.
Yeah. I believe what happened was he was stopped on this number 3 case.
Right, on the traffic, and then they saw the other. Okay.
Yeah.
All right. Let me hear on traffic. He's not recommended UJR on either because of the history, but I will On this theft case, I will give a $500 surety bond for this case. No drugs, alcohol, or weapons while on bond. And stay away from Georgia Tech, from all of their properties. And no further contact with Dominique Young. And that will be my ruling on this case. Anything else I need to take up on this case? And I guess you all can sort the other things out later.
What about the third, is it the third case for the traffic violations?
Right, we'll hear that one next.
Okay.
Okay, all right. And then this case is 22 CR 003381F. And again, Mr. Marlon Bowie, you're charged with driving while license suspended or revoked, failure to obey traffic signs and signals, and an improper left turn with the offense date of May 27th, 2022. And I've already heard his history from pretrial, and I already know that. Mr. Borger, tell me about this case.
Thank you, Your Honor. The bond is currently set at $1,530 total. We are asking that Your Honor keep the bond the same. The breakdown on this is $265 for the failure to obey traffic signs, $265 for the improper left turn, and $1,000 for the driving while on a suspended license. I will note in favor of keeping this as a surety bond. The license was suspended for an FTA. So that, combined with the fact that this defendant is a multi-state offender, obviously has the usual warning signs of a lack of confidence this defendant would show up for this case as it moves forward in our system. So we do ask that you keep this at a $1,530 surety bond. Nothing further from the state.
All right, Ms. Hogue.
Yes, Your Honor. Mr. Vile was raised in Chicago, but has significant family here, including a grandfather who he came down here 4 years ago to start taking care of. So that is why he's down here, to help take care of his grandfather. He was working as a forklift operator at Sunoco until it closed, Your Honor. So he was making money and working, but right now he is in between jobs. So he is financially strapped, Your Honor. He has a grandfather here. He has aunts and uncles here, and he also has a younger brother here. So he has significant family ties. So he is not a flight risk. Given that we're not hearing anything in his bag, we're hearing that the license was suspended or revoked due to an FTA and not due to any kind of traffic situation, Your Honor. So I'm not sure, he might not even known it was suspended. So I would ask, Your Honor, for, if not signature bonds on these, for the minimum of, 500, 265, and 265 good bonds, or all signature bonds. I don't see anything that warrants anything else at this point.
All right. I'm going to order that the bond remain the same, the 1,530 surety bond on this case. No drugs, alcohol, or weapons while on bond. And Mr. Bowie, no driving while you're on bond until you get a license, a valid license from DDS. Looks like your license is suspended or revoked, so you should not be driving, and you'll have to do ride shares or cabs or whatever to get around. But you are not to drive until you get a valid driver's license from DDS. And again, no drugs, alcohol, or weapons while on bond. So I will keep it the same at the 1,530 surety bond, 1,000 on that suspended license, and 265 on the other two, Michael, the failure to obey and the improper left turn. All right, that should conclude this case. Thank you.
Position 14.
And Your Honor, if I may, before we move on, I understand that Deputy Folk called Chamblee PD and got a voicemail. Additionally, our victim advocate reached out to the alleged victim in position number what is it? Position number 10.
Right.
And that number it did not go through. So the state is, of course, again asking for that no further contact condition.
Your Honor, I wasn't able to reach out to her because I had to take care of Mr. Buell. So right now I won't have anything, so I'd like to reach out to her now.
Okay, so you want to hold a second while you do that, Ms. Holt?
Yes, please.
Okay, we'll hold for a few more minutes on position 9. Is that position 9?
Position 10.
I mean 10, I'm sorry. Yeah, let's hold 1 second. Let me do one more while Ms. Holt makes that call real quick.
Position 14 is in front of you.
Okay, thank you. This is it DJ Santillian? Santillian?
Yes.
Okay, 22 CR 003372E. You're charged with 1 count of battery, family violence, 2nd count of criminal trespass, and a 3rd count of cruelty to children in the 3rd degree. Offense date May 27th, 2022. Pre-trial?
There no prior history. He is recommended for UJR through pretrial. If granted, he will need a parental cosigner.
Oh,
Nothing further.
all right, I'm sorry, Ms. Gardner.
Thank you, Your Honor. In this case, the defendant was arguing with his stepfather about him and his younger siblings and his cousin watching a movie that his stepfather felt was inappropriate. In response, the defendant punched his stepfather's mouth multiple times with a closed fist. The law enforcement officer observed visible injuries, including a swollen, split, and bleeding lip. He also struck the 62-inch wall-mounted television, causing damage to that. And he did all of this in the presence of the children who were there, which include his 4-year-old brother, his 10-year-old sister, his 14-year-old brother, and a 14-year-old cousin. Everyone who is present except the cousin do reside in the same household. The state is asking for a total of a $4,500 good bond. That would be $2,500 on the battery, family violence, $1,000 on the criminal trespass resulting from the damage to the television, and $1,000 cruelty to children in the 3rd degree. We're asking also that he be required to take the family violence intervention program, to stay away from the home at 195 Fall Creek Trace in Roswell, and that he have no contact with his stepfather, Gilberto Vallejo Sanchez. Also that he have no alcohol, no drugs, and no weapons while on bond.
Okay.
Yes, Your Honor. DJ is 18 years old. Currently, he's attending Peak Academy in Roswell. He is a lifetime resident of Roswell, Georgia. He does not have any children, and he's not currently working. Again, Judge, he attends Peak Academy High School. Judge, when I spoke to DJ, he understands the seriousness of this case, Judge, and it is his first arrest. I do believe that you heard. Judge, we're asking for a signature bond. We are asking for him to be able to return to 19 Fall Creek Trace. If the victim advocate has gotten in contact with Mr. Sanchez, if he would allow Mr. Santillian to return to that location. And I'm also asking for no violent contact with Mr. Sanchez because again, Judge, DJ does live there and has resided there, Judge. So Judge, we are asking for a signature bond. This is his first arrest. I do believe he'll come to all his court dates. Yes, DJ, if you have any details about the case, I advise you not to speak about the case, but if you just want to tell me something, you can.
It's like, if I don't want to go back over there, like, because I don't feel safe, or like, I don't want to make more problems.
Do you have another address that you can reside?
Yeah, I probably have my auntie. I just have to speak with her.
Correct. And Judge, he did inform me that he does have family ties, community ties here in Georgia. He didn't have the exact address of aunt's address, but if he's not allowed to return back to the 195 Fall Creek, he does have an address with aunt. I just didn't have the specific address from him.
Yeah, I don't know the address like that.
Well, is he going to have someone to call to sign for his bond?
DJ, do you have aunt's number? Is aunt over, I think it's 25, Judge? Don't they have to be over 25?
Correct.
What was that, DJ? Do you have aunt to be able to sign?
Yeah, I just gotta get her number.
And I think that was just the issue. He just didn't have the contact information on him, Judge, because I would have called to see if that was the case.
Well, I'm not trying to be funny. How's he going to get it?
DJ, is it in your phone? How are you going to get it?
When I got arrested, my mom took my phone, so I ain't got nothing.
So how are you going to get aunt's number?
I can probably call my mom when I get a call. And
Okay, can I get mom's number? Just give it to me now.
Yeah, 678.
Yeah.
629 1612.
678-629-1612.
Yeah.
Judge, I can make that call now if you'd like me to.
Well, yes, I'll go ahead and give my ruling. Of course, he's not going to get out until someone comes to sign.
Understood, Judge.
I'll say that it'll be the aunt. It could end up being an uncle. I don't know that I know that pretrial likes to know who more specifically. Is that correct, pretrial?
Yes, Judge.
Can I put down
You'll have to give
mom?
us his aunt's name.
Can I give mom's information and aunt's information?
That's fine.
Who's the parent?
Mom.
So it would be her information with, and she will also need a bill that has the same address as her driver's license.
Understood.
Is that the same requirement if the aunt bonds him out?
If that's where he'll be staying.
A bill matching address.
Mhm.
Because I'm just wondering, I'm going to go ahead and give him a signature.
Unless, Your Honor, you can change it to an adult cosigner.
Adult cosigner.
Okay.
But the information still needs to match, and I still need to know that name.
Okay.
And DJ, what's mom's name?
Janet.
Janet?
Yep.
Thank you.
Janet Santillan or Janet Sanchez?
Janet Santillan.
And is it possible, because again, mom, I guess is married to Mr. Sanchez, correct?
Yeah.
Tell us your aunt's name.
Norma Santillan.
Okay.
So I've sent mom's name and number to pretrial.
Okay.
So will the mom be the cosigner?
I'm not sure.
If you'd like me to call her and verify, I can. I can do that right now.
Yes, I think we'd like to do that because I don't know, we're talking about him and this incident occurring with the stepfather who's married to the mother. Is that correct?
Correct, Judge.
And so I don't know what conflict it could cause. And so it may be that mom may or may not be able to do that. Then we would put the aunt down. We just need to make sure which person.
Your Honor, Ms. Taylor advised that she does have the mom on the phone at the moment.
Oh, wonderful.
Your Honor, would you like to hear her on speaker?
I trust you, Ms. Taylor. I may not be able to. She asked her the appropriate questions if she's able to bond out her son, or co-sign, should I say.
Ms. Santillan?
Yes, ma'am.
This is Millicent Taylor, the victim advocate. You're in the courtroom in regards to your son, DJ, and his attorney, public defender Catrice Helen is here as well as Judge Mincy. Please advise them what you informed me.
Oh, yes, that he's gonna be going to my sister's house.
And what is her name?
Rafaela Santillan.
If she could spell that.
Rafaela. Rafaela Santillan, Santillan.
All right, would she be able to come to the jail to co-sign on the bond for your son?
I'll be co-signing for him. Is that possible?
That's
No,
not acceptable.
It has to be the person
Dice
that's,
que se hace cuenta, si él regresa a la casa, yo tengo que ir a firmar, pero él no quiere venir a la casa, entonces dice que si podemos, like, si él se va a quedar a tu casa, tú tienes que firmar por él. But what would be the co-sign for? Is that like attending back to court, or is just like to release him to come out?
all of the above, all of the above, both. And that's because he's 18.
He's
And
17.
I'm sorry,
If he
17.
was 18, it would be okay, but he's
Yeah,
17.
I'm sorry, 17. And is your sister, is she over 25?
Yes.
Okay. And so will she be able to come down? I mean, you can come together, but she will be the one co-signing on the bond because of his age, as well as the one responsible for making sure he gets back to court. And it sounds like he's going to be residing with her as well.
Okay.
Okay. And she will
Yes.
have to bring a utility bill that will match the address on her driver's license.
Okay.
Okay, she'll be able, let her know that.
Okay, dice que para poderlo sacar necesitamos un bill y no vamos a tener que pagar nada, nada más. De eso yo me voy a asegurar que tenemos que ir para atrás a corte.
And what is her telephone?
Para que él pueda salir. Okay.
Okay,
Yes.
all right.
and what is a good telephone number for Rafaela?
770-873-2257.
Understood.
All right, is there anything else you need pre-trial?
No, she knows where to go.
Does she know where to go? I guess Miss Taylor, make sure she knows. Okay, Miss Taylor, make sure she knows where to go. All right. All right, there's nothing further. I'm going to, again, order a signature bond through pretrial. We have the aunt's information who is going to be co-signing on that bond. And that bond amount is $4,500. So it's a $4,500 signature bond through pretrial. No drugs, alcohol, or weapons, Mr. Centillion, while you're on bond. And you are to stay away from the residential location of 195 Fall Creek Trace in Roswell. You are not to go back there, all right, while you're on bond. You understand? Can you hear me, Mr. Centillion?
Yeah, I understand.
Okay, and you are to have no further contact with Roberto Sanchez.
Okay.
All right, do not have any contact with him while you're on bond.
Okay.
And I'm also going to order that you take the anger management course through pretrial. That is going to also be a condition of your bond.
Is that the one day, Judge?
Yes. All right, so that should conclude this matter unless council has anything else.
No, Judge.
Thank you,
Nothing from
Ms.
the
Taylor, I
speaker.
appreciate that.
Judge, what's the breakdown on the bond?
Oh, I'm sorry, 2,500 on the battery, 1,000 on the criminal trespass, and 1,000 on the cruelty. And I think I did my math correct, did I, Michael?
I'm sorry, Judge, one additional thing. Will someone be translating for her once she arrives at intake?
It sounds like she may need that.
Okay.
Deputy?
The mother will be coming with her sister.
Okay, so
thank
she'll be able to translate. All right, thank you. All right, who do we have next?
This is position 5.
Okay. This is Mr. Damani, 22 CR 003364E, and you're charged with 1 count of license required to distribute, sell, or otherwise deal in alcoholic beverages. and the display event license. The offense date is November the 18th, 2021. Pretrial?
Your Honor, no prior history. He is recommending for you jail through pretrial, nothing further.
All right, Mr. Borger?
I'm comfortable with the signature bond on this case, to the judge's discretion.
Okay. All right, and Ms. Hogue?
Yes, we would like to ask you to honor the signature bond as well. He is 38 years old. He has no history whatsoever. He has significant ties here, so there's no reason why he shouldn't be granted the signature bond.
All right. And where did this occur, Mr. Borger?
Yeah, Your Honor, just briefly with the facts. This defendant, he owned and operated a small market type store. This store sells beer and wine. It's on 1294 Donnelly Avenue. The defendant actually has it looked like a state license to sell beer and wine, but not a City of Atlanta license to sell beer and wine. Yeah, frankly, I don't know how this defendant was held without a bond. But yeah, again, he was just didn't have the proper licensing that was necessary to sell beer and wine.
Okay.
And to clarify, Your Honor, I think there's some questions to who is actually the owner and everything else. That's why it's a bit confusing, to be honest with you. I think it's just something they're going to have to straighten out.
Straighten out. Okay. All right. I'll order $1,000 signature bond through pretrial. And no drugs, alcohol, or weapons while on bond. And that should clear this case. Is anything else I need to take up?
Not from the defense, Your Honor.
Okay, thank you.
Next is position 20.
I believe that's Zazinski, Judge.
Yes. 22 CR 003376G. Mr. Zazinski, you're charged with 1 count of battery, 2nd count of simple battery, both with the offense date of May 27, 2022. Pretrial?
No prior history, Judge. He is recommended for a pretrial. Again, if he is granted, he will require a cosigner as well.
Okay. All right, Ms. Gardner?
Your Honor. In this case, the defendant was arguing with his brother, Zion, over the keys to the family vehicle. When Zion refused to give them to him, defendant struck him and put him in a headlock. A friend who was also present, Gavin Bootkin, heard the scuffle and went into the bedroom where the brothers were to found the defendant with his brother in a headlock. He attempted to intervene and the defendant punched him in the head. The law enforcement officer noted visible marks on Zion's chest, shoulders, and back. The state is recommending and seeking a $2,000 good bond. The 1-day anger awareness program, no further violent contact with Zion Zazinski or Gavin Bootkin, and no alcohol, drugs, or weapons while on bond.
Yes, Judge. Mr. Zazinski is 17 years old today. I think you did hear from pretrial services. This is his first arrest. So, Judge, we are asking for a signature bond. You did hear the allegations in the case, Judge. But when I spoke to Mr. Zazinski, he's not currently working because he's 17 years old. He currently attends John Creek High School. He's a lifetime resident of Fulton County, and he doesn't have any children. Again, he's 17 years old, Judge. I did speak to him, Judge. He would like to return to the 11120 Indian Village Drive. Again, that has been his primary address. However, when I spoke to him, he does have another location he can reside at with his father at 706 Tilbert Street. Also, Mr. Zazinski, if you can give me a good working number for Dad, because I do believe that that would be the person who would be signing for him as well.
Okay. Yes, Mr. Zazinski, do you know your father's number?
Yes, ma'am. 770-391-8476.
Give me dad's first name.
Jeff.
Is his last name Zazinski?
Yes, ma'am.
And I'm sending that information to pretrial right now.
Thank you. All right, I'm going to order a $2,000 signature bond through pretrial, 1,000 on each charge. No drugs, alcohol, or weapons while you're on bond, Mr. Jazinski. They take the one-day anger awareness course. You're going to stay away from 1120 Indian Village Drive. Do not return there. Actually, I might allow a one-time police escort if you need to get any personal belongings or clothing from there. But you must go back with the police, not by yourself. And a no further contact with Zion Gazinski or Gavin, is it Buckner or Buckin?
Bootkin, Bootkin.
Oh, I really messed that up. Bootkin, yes.
And judges, and no violent contact or no contact at all?
So those are your brothers, Mr. Zazinski?
It's the other one is my brother's friend.
I'm gonna order no contact right now. Because if he's not residing in the home, he doesn't need contact with him right now.
Understood.
All right, anything else, counsel, need to take up?
Nothing from the state, Your Honor.
No,
All right.
Judge.
Thank you. That will conclude this case.
All right, you're done. Next is position 11, Logan.
Sorry.
Both out of each 2,000 total.
This is 22 CR 003369E. Jacob Logan, you're charged with 1 count of battery family violence. The offense date is May 27th, 2022. Retrial?
Third arrest. Last arrest was December of 2021 for failure to appear in DeKalb County. Underlying charge is possession of marijuana with intent to distribute. No disposition listed in that arrest. Record indicates a 2018 burglary, first degree, 2 counts. In DeKalb, it was first offenders and sealed in 2019. Nothing further to add.
All right, Mr. Borger.
Thank you, Your Honor. The state's asking for a $5,000 surety bond. In this case, the defendant had struck his roommate several times on the head, causing some visible swelling and laceration to his roommate's head. So along with that $5,000 surety, we're asking for the conditions of no further contact with Madison Powell. Madison is going to be spelled Madisen. Madison Powell. Stay away from 2323 Tiger Flowers Drive. Enrollment in our one-day anger awareness program, and no guns, drugs, and alcohol while on bond. We do see an FTA from this defendant, so we would like to keep that surety in place. Nothing further from the state.
All right, Ms. Holt.
Yes, Your Honor. Mr. Logan is 23 years old, Your Honor. He has his GED, as well as he's also become a certified mechanic in certain areas. He has lived in Georgia all of his life. All of his family is here. He is married, and he now has a 1-month-old baby as well. So he has significant ties here, so he is not a flight risk. In this case, to clarify something here as well, Madison Powell is not, in fact, his roommate at all. In fact, he and his wife have been living in this house, okay? And Madison Powell was, in fact, the lessee and sublet it to them under false pretenses. That's one of the problems that they're facing. And in this instance, she came over and burst into the house, and he's the one that called the police. But somehow this all got flipped around, that somehow he did a bunch of stuff that he did not do, and he categorically denies. One of the problems that I imagine Ms. Powell is facing right now is that the owner found out that she illegally sublet because she was not allowed to. So now not only does Mr. Logan have to get out, but so does Ms. Powell. Okay, because like I said, she did it under false pretenses. At this point in time, like I said, Your Honor, he was working. However, right now he does have an interview with Walmart, but he's been out of work for a couple months now, so he is financially strapped. Based on his history, what we have is he successfully completed a first offender, and that's a lot to be said that he did. An FTA in 2021 does not seem to have gone anywhere other than that, Your Honor, and other than that, he has no other real history. We are asking for a signature bond, given he is strapped. His wife has a 1-month-old. And so right now they're just simply trying to move out of that location. They have no desire to have any contact with Ms. Powell, since she did falsely allow them to sublet when they couldn't. So now they're being evicted to no fault of their own. But they do want to get out. They want to get out as quickly as possible. I spoke with his wife today. She just needs him out because she's got the 1-month-old. She's had to quit school and everything right now until the baby gets older. So they're down to a single income. So we are asking for, at this point in time, a $2,000 signature bond. In the alternative, if not that, then a $500 surety bond. So that he can get out, they can get moved out and everything, and take care of all this mess that Ms. Powell put them in the first place. I would imagine Ms. Powell was pretty upset when it turned out that now she's also going to be kicked out of it for her inappropriate activities.
All right. I'm going to order a $3,000 signature bond through pretrial. I'm gonna order the 1-day anger awareness course. No drugs, alcohol, or weapons while on bond. And stay away from 2323 Tiger Flowers Drive. And I'm assuming with ordering the stay away, I guess he has no choice but to stay away. I was a little hesitant to say that because I guess he needs to go back there to move out.
That's correct, Your Honor. So really what they'd like to be able to move out by tomorrow. That's what they're trying to do. But with the 1-month-old, she really can't do anything without him. It's just a little bit too much. So I would just ask for her, them be able to go back, get all their things and move out.
Okay.
That's really what they want to do. They have to, Your Honor. They're being evicted because Ms. Powell was not supposed to sublet in the first place.
All right, well, I will remove the stay away so that they will have ample time to move out, to move their things out, but no further contact with Miss Madison Powell.
Yes, Your Honor. Ms. Powell doesn't actually live there, other than the fact that now that they're moving out and the real owner doesn't want, I guess, is upset that she did what she did. So she's going to be forced to relinquish her lease.
Right, but since they did have a alleged fight of some sort, or the striking allegations with he and Miss Powell, then I'm going to make sure that he stays away from her right now.
No problem, Your Honor.
Okay. All right. Anything else from counsel?
No, not from the defense, Your Honor.
Only from the state.
And where are we circling back? Are we able to circle back to position?
Position number 10.
I don't know if Ms. Taylor, I sent her the information. I don't know. Oh, she was able to speak. Okay.
So, yeah, and I can defer to Ms. Taylor, but I've also spoke with Ms. Taylor. There's been a history of violence.
Hold on a second. Deputy, is this position 10?
Yes, we
Mrs.
can do
Jones?
position 15 first and then do him last.
Oh, okay, we're gonna do it last. Okay, I'm sorry. So this is position 15 first. All right, this is Rayfield Simpson.
Yes, Your Honor.
Okay. This is case number 22 CR 0033 7(3)(b). You're charged with lauder prowling. The offense date of May 27, 2022. Pretrial.
7 cycles with history in Georgia and Maryland. Last arrest April of this year for criminal trespass and giving false name in Fulton County. Record indicates the defendant is currently on probation in Fulton County for simple battery, 21 CR 005296Y. Sentenced January of 2022, 12 months probation. Additional open probation for criminal trespass, 21 CR 007590Y. Sentenced January of 2022, 12 months probation. 2 failure to appear within the past 10 years and a 2017 misdemeanor conviction for violation of protection order. Nothing further.
All right. No, Ms. Gardner. Sorry.
Thank you, Your Honor. Your Honor, in this case, the defendant was caught on a surveillance camera walking around a parking garage, going into a stairway, smoking some substance believed to be drugs, and touching himself inappropriately. The incident report advises that he was also breaking into a vehicle. When questioned, he would not say why he was in that particular garage doing those things. The state believes there is a very significant risk that he will reoffend. We see 3 prior criminal trespass convictions just in Georgia. He's on probation already in 2 open cases and is back before this court again, and he's had 2 failures to appear. We would ask that he be required to have a good bond in the amount of $3,000, that he stay away from the parking garage at 815 Williams Street Northwest, and that he have no alcohol, drugs, or weapons while on bond.
Okay.
Yes, Judge, Mr. Simpson is 29 years old. He is currently employed, has been for the last 3 years with the Pay Center, Judge. He does have a 12th grade education and has received his GED. He is from Maryland, but however, has been in the Georgia area for the last 5 years, specifically Fulton County. He is a proud father of 2 daughters, Judge. One of the 2 big things Mr. Simpson talked to me about is, number 1, he believes he's going to lose his job if he is not able to soon be released from the Fulton County Jail, as well as his 2 daughters. He is one of the primary caregivers of his 2 daughters. So as he's being incarcerated, he's not able to provide for his family, Judge. Again, we are asking for a signature bond. I did hear the allegations of this loitering and prowling again, Judge, but I did not hear anything about anybody being aggressively approached or any allegations of any violence towards anyone, Judge. When I spoke to him, he told me he was minding his business. And that made any contact or any other contacts with any person there in that garage, Judge. So that's why we're asking for a signature bond. If you feel that he's ineligible for that signature bond, Judge, I'm asking for a surety bond of no more than $1,500. Again, anything more would be a no bond for Mr. Simpson, who is trying to get released to maintain his employment, again, for his family, and then to be able to go back to that family, Judge.
All right. I'm going to order a $2,000 surety bond and a stay away from 815 William Street Northwest. No drugs, alcohol, or weapons while on bond. And again, Mr. Simpson, make sure that you do not go back to the William Street, to that location. I guess the complex and or the attached garage, don't go back there at all, or you will be arrested.
No, I didn't hear what you said. You said a surety bond?
Yes, a surety bond of $2,000.
So I have to pay, the,
You'd have to pay a bonding company. Yes, Mr. Simpson.
okay.
Okay,
You said $2,000, right?
yes.
All right.
All right, that will conclude this case.
Thank you, Judge.
Going back to position 10, Jones.
Okay.
Hey, Miss Elizabeth.
Yes, Mr. Jones, I'll speak to you outside of this, okay?
Okay. Requires one quick question, so the judge should have.
And if it's not about the process is one thing, but not about any of the facts of the case, you do understand?
No, it's just something I wanna ask. I just wanna know, cause I can't afford remember I was telling you, I couldn't afford to bail myself out because I have no one to sign.
Yeah, that's okay. We'll address that.
And I was trying to see, can I get a jail signature?
Well, like I said, we'll be addressing that, Mr. Jones. Don't worry, we'll be addressing it.
Yes, ma'am.
All right, what is the update on this case?
Thank you, Honor. Our victim advocate spoke with the victim in this case. Briefly, the histories, they've been together for about dating for about 3 months. And in that 3-month period, the victim alleges that she's had to call the police at least 7 times during the relationship. I do concede that indeed the victim is 7 weeks pregnant, not 7 months pregnant, but does agree that the anger management classes would be appropriate, and she is concerned about this defendant's anger. In terms of the injury received, there were no stitches. The nose was, or the area in between the eye, the bridge of the nose, was glued together and not stitched. So I guess that would, I suppose, maybe not make this case a felony, but nonetheless, we still have a victim who was hit in the face, had to go to the hospital. Police called 7 times. She's clearly in fear of being hurt again. So the state is asking for a surety bond to remain, along with a no further contact.
Okay.
Your Honor, my understanding is she wanted contact. I'm not hearing that you said she didn't want
Yeah,
contact.
she wants contact, but we don't want contact because that she got hit in the face by a gentleman in jail right now. And she's clearly afraid, as the police have been called 7 times.
That's kind of, never mind.
As the victim is not the prosecutor, and we are asking for no further contact for the safety of this woman.
And I understand, is this location, the 302 Mansell Road, is that the Ramada Inn?
That's a Ramada Inn, and the victim, she alleges that she has a place that she can stay, which is why this no further contact should not be an issue. She's not going to be living with this defendant.
All right. I guess based on our updated information, I'm going to order a signature bond in the amount of $4,000. I'm going to order no further contact at this time with the victim, Rhonda Blassingame. I'm going to order no contact so that we make sure that she is safe and that there is a cooling off period. I will not order a stay away from the Mansell Road because it appears the victim will not be residing there. And they may have lost that location anyway. It's a Ramada Inn. But I will say to you, Mr. Jones, since you have to stay away from Miss Blassingame right now, and I understand that she is pregnant. Hold on, I'm talking.
Mr. Jones, please do not talk.
I'm talking, so you cannot talk, Mr. Jones.
Sorry, Your Honor.
Okay, and so even though she may be pregnant, and I understand that, I want there to be a cooling off period, and we must ensure that she is going to be safe.
Yes, ma'am.
And right now, that is my primary concern. So stay away from her right now, because I think that is warranted based on the allegations. And if you go back to that Mansell Road and she is there, I need you to leave because you cannot be around her and you cannot have any contact with her if she has not moved all of her things out by the time if you bond out and when you bond out and go back there. So I want to make that clear to you, okay?
Can I just say one thing?
Mr. Jones,
Probably
please do
not.
not
I do have
speak.
a
It's not about
question.
the case. It's not about the case. The room is in my name, so they're not gonna let her just go without my. you
Okay,
know,
well, that's
Mr.
fine.
Jones, they will let her go because you're the one that has to pay, not her.
Your Honor, I have a question.
Yes, ma'am.
I surrendered a bond on this defendant. So you get putting him back on pretrial?
No, it's a surety bond. I'm sorry.
You said signature bond.
Did I say
Yes.
signature? I
Yes.
did not mean that. Please excuse me, everyone. I'm so sorry.
What's it, Miss Elizabeth, what's it?
I meant a
Okay.
$4,000. What I wrote was a surety bond, so I did not mean signature bond, because you're correct.
Okay, Your Honor, he has very limited income, and now with the stay away and everything else, Your Honor, we would ask that be, if it's not going to be a signature bond, Your Honor, that it be no greater than a $500 or $1,000 surety bond.
No, I'm comfortable with the $4,000 surety bond.
I
You know,
can't afford
10
that.
to 15% is not a lot of money. I think you had given me some type of employment with him as a card detailer or something like that.
Yes,
Yes,
please. Okay, Mr. Jones.
Yes, ma'am, I'm sorry.
Okay, I believe he has now lost that position. That's why, Your Honor.
Okay.
So
Well,
he will not have income.
well, because we're revoking him, I'm going to leave it at the $4,000 for a surety bond, I apologize. And a no further contact with the victim, Rhonda Blassingame. There will not be a stay away in place, but
About my service dog.
I'm sorry,
Mr. Jones, please remain quiet.
you have a service dog at that location?
They locked my dog up in
Okay,
Roswell.
Mr. Jones, please remain quiet. That's not this court's issue, okay?
You'll have to deal with your dog once you get out, once you make bond. But it'll come back for bond review if you're not able to make bond.
Can you lower it, please, Your Honor?
And Mr. Jones,
Nope.
please we'll
I
talk after
cannot
this.
lower it. Well, the state was asking for 8,000, so I gave you a little bit of leeway there, and I ordered a $4,000 surety bond. So the state was requesting 8,000. And so given your history, I think that is fair, okay? Deputy, there was one case, I think did we do number 4 or has he been released?
Position 4 is waived at their appearance.
Yes, Your Honor. Position 4 is I have interviewed him. We are waiving his appearance. We're just asking for his bond to remain as it is at this point. I believe he has like a $1,000, $1,500 bond. This is an MH case where our kid social worker needs to speak with him. So at this point, we're just asking for the bond to remain as is, and time now for our social worker to speak with him. But I did speak with him so we can waive his appearance.
All right, what do you have, Mr. Porter?
Well, first off, with the current position that we're on, will there be any conditions of no guns, drugs, and alcohol while out on bond?
Yes, thank you, Mr. Porter. I'm sorry. Yes, no drugs, alcohol, or weapons while on bond.
Okay.
Yeah.
And so the other case that we were referencing, is this Mr. Butler?
Yeah, that's the case we're representing.
Okay, the state totally objects. We're asking for an $11,000 cash bond.
Your Honor, Mr. Butler has no funds, no way to make any bond. To ask for $11,000 cash bond is ridiculous. We're just asking for it to remain as it is. He is an MH case regardless, and he will not be getting out anytime soon.
My concern is, well, there's no bond currently set, Your Honor, but in this case,
I thought he had a bond set.
the defendant is accused of waving a gun on a MARTA train. I don't need to remind this court that.
Hold on, Mr. Porter. Let me call this case 22 CR 003380D. I thought it was simpler than it is, and I apologize. Mr. Tony Butler, his counsel has waived his appearance.
Yes, I have, Your Honor.
Okay. Let me start off pretrial. What do you have?
24 cycles. Last arrest, April of 2022 for criminal trespass in Fulton County. No disposition listed on that arrest. Record does indicate a 2021 criminal trespass conviction in Clayton County, along with a simple battery conviction. 2020 and 2019 criminal trespass, 2018 and indecency conviction, 2013 and 11 criminal trespass. Nothing further.
All right. Thank you.
Oh, sorry.
All right, Ms. Borger, Mr. Borger.
Thank you, Your Honor. The state's asking for an $11,000 cash bond. I understand this bond amount that I'm asking for is abnormally high in this courtroom, but the defendant is accused of waving a weapon in a MARTA train. We've seen random acts of violence on trains in the past 2 months. People dead, people shot on public transportation. Not to mention the amount of stress and strain that placed on our MARTA and APD for receiving a call 1-2 days after a massive school shooting. They get a call that a gentleman is waving a gun in a MARTA train. That is a very delicate and stressful situation. MARTA probably lost the entire ridership of the people who were on that MARTA train when this individual began waving a gun on the train. We're dealing with potential post-traumatic stress from this incident. I understand that this defendant might be a mental health case, that this defendant has no funds, but it's important that he's accounted for. And that's why we're asking for an $11,000 cash bond. That's $10,000 cash for the reckless conduct, $1,000 for the criminal trespass. He's been criminally trespassed from MARTA previously. There's just no excuse for waving a gun in a subway train. Again, this country, we've seen way too much gun waving around, entirely inappropriate. And this defendant needs to be accounted for. Nothing further.
So the allegations are not that he left it on there, that he waved it around.
Correct. The incident report states that he brandished a gun. Placing the train in fear. And even if you left the gun on the train, that's extremely dangerous and incredibly frightening. Again, a stressful and delicate situation that our police have to respond to, that requires perfection when responding to those types of cases. They don't deserve that kind of strain. The MARTA ridership doesn't deserve that kind of stress. And the county of Fulton does not need that.
All right. Thank you. Ms. Holt.
Your Honor, as we said, Mr. Butler is an MH or mental health case. Okay. All we know right now is he allegedly brandished this. We don't have witnesses at the interview. We don't have anything to blow this to a, potential PTSD scenario and everything else. I think is going way over the line. He has no resources. He will not be making bond. Okay. But to set an $11,000 cash bond is just absorbing it. I believe that a regular surety bond will more than assure he stays in jail. The bond could be set at $1 million. Quite frankly, he's not going to make it. We'd like a reasonable bond so that it can be worked with, so that we can work with whatever mental health issues and our social worker can work out, such that we are not constrained by some type of incredible bond either. Your Honor, I think that a reasonable, even a $10,000 regular bond is more than reasonable at this point in time. All we know is he brandished it. I believe you say he's waving it and everything else. I've seen these waving cases, and every time I've seen a waving case, it's never been a waving case. All we know is he allegedly brandished it without any list of passengers who we have that.
I have a passenger on the warrant. I have a passenger on the warrant. I mean, the police responded.
A passenger on the warrant.
Someone called it in. Brandish, waved. There was a gun on a train. Entirely inappropriate.
Guns on trains are allowed. You do understand that, right? It's legal.
Right, and they cannot be brandished in front of people. They need to be properly holstered.
And do we know if it was loaded?
They need to be properly holstered. We can figure out if it was loaded at a train.
Right. Well, I recognize MH, and is there an order signed for the MH eval?
No, Your Honor, like I said, the reason why we went ahead and just waived, I interviewed him so they would not have to come before the court again. So what we are going to be doing, this is like I said, he was just arrested, Your Honor. So we have to actually go and have the social worker do the interview and do an official and then request for an evaluation. I have no doubt that he does need one, having spoken with him.
I'm a little concerned about the fact that if an MH eval order has not been presented to me, I don't want it to get lost in the shuffle and he not have it, and then be able to bond out. And I'm looking at, if my math serves me correctly, he's 65 years old.
Yes, Your Honor, he's 65 years old and has no financial resources, no family, no anything. He will not be bonding out.
I mean, the allegations are pretty serious. I would, beg to differ and take them to be very, very serious. So what I'm going to do is I'm going to order a $5,000 cash bond. And that will be the ruling for the court. He's to stay away from all MARTA. And I want to make sure that he gets his MH eval as well. And no drugs, alcohol, or weapons while on bond, but I will at least make it a $5,000 cash bond.
Okay, Your Honor.
All right, thank you. Is there anything else? Have we missed any cases, Mr. Jordan?
Is that 2,500 per charge? Judge?
I'm sorry?
Is that 2,500 per charge?
Oh,
The
yes,
breakdown?
I'm sorry, I had to break it down. 2,500 cash per charge, yes.
Mhm.
And I think we're ready to reconcile, you tell me.
Yes.
Making sure I don't see anything that we've missed.
You said stay away from MARTA and no drugs, alcohol, and weapons for that last case?
Correct.
Okay. So SAP reset date is June the 9th, 2022. The position 1 was a 1,500 surety bond, reset SAP. Position 2 was a 500 surety, reset SAP. Position 3 was a $1,530 surety, reset SAP. Position 4 was a 5,000 cash bond, reset SAP. Position 5 was a $1,000 sign-on bond pretrial. Position 6 was a 5,000 surety, reset SAP. Position 7 is a $5,000 sign-on bond pretrial. Position 8 is a $5,000 sign-on bond pretrial. Position 9 is a 1,500 surety, reset SAP. Position 10 is a 4,000 surety, reset SAP. Position 11 is a $3,000 sign-on bond pretrial. Position 12 is a $3,000 sign-on bond pretrial. Position 13 is a $2,000 sign-on bond jail. Position 14 is a $4,500 sign-on bond pretrial. Position 15 is a $2,000 surety, reset SAP. Position 16 is a $3,000 sign-on bond pretrial. Position 17 is a $2,000 sign-on bond pretrial. Position 18 is a $3,000 surety, reset SAP. Position 19 is a $2,000 surety, reset SAP. And position 20 is a $2,000 sign-on bond pretrial.
All right, any questions, errors, concerns?
No, Your Honor.
All right, everyone, enjoy your holiday and extra day off.
Thank you so much.
Thank you.
All right, thank you. All right.